Have you ever been fired or disciplined at work and the reason just didn't sit right with you? You felt like something else was going on behind the scenes? If so, you might have experienced what's called pretext. And in today's video, we're going to break down what that means, how it works in an employment law case, and how you can prove it. Let's start with a simple definition. Pretext is when your employer gives a false reason for firing you, demoting you, or taking some other negative action, but that reason is just a cover. The real reason is something they don't want to admit, like discrimination or retaliation. Here's a quick example. Let's say you report sexual harassment to HR and 2 weeks later you're fired, and the company says it's because you were late to work too often. But you've never been written up for being late before. In fact, lots of other employees come in late and nothing happens to them. That's when the lateness might be a pretext, a made-up reason to hide the real reason, retaliation for your complaint. When does pretext come up in a lawsuit? In most employment discrimination or retaliation lawsuits, the employer will almost always say, "We didn't discriminate, we had a legitimate reason for our decision." Your job as the employee, or your lawyer's job, is to prove that reason isn't the real reason. That's where pretext comes in. If you can show that the employer's stated reason is false or suspicious, it can support your case. So how do you actually prove pretext? That's a great question. Here are a few key takeaways. Number one, inconsistent reasons. If your employer keeps changing their explanation or gives different reasons to different people, that can be a red flag. Number two, comparative evidence. Show how others were treated differently. If other employees did the same thing and weren't punished, that could show you were singled out. Number three, timing. Look at the timing of what happened. If the negative action came right after you filed a complaint or took protected action, it may be retaliation disguised as something else. Number four, lack of documentation. If your employer claims they warned you or documented issues, but they can't produce any of that paperwork, that's suspicious. And number five, positive history. If you had good performance reviews, bonuses, or no disciplinary history, then suddenly get fired for poor performance, you can argue that doesn't add up. Proving pretext can be tough, but it's not impossible. If you suspect your employer took action against you for the wrong reasons and the explanation they provide just doesn't feel right, you may have a case. If you want to better understand your legal options, book a consultation with our team. We'll help you figure out if pretext is part of your case and what steps you can take. Thanks for watching, and remember, just because your employer gave a reason doesn't mean it's the real one.